Good morning, everybody. My name is Jackson.
I'm Nate.
I'm Julia. I'm Caitlin.
I'm Jonathan.
I'm Sarah.
We did our presentation on the Supreme Court. Basically, the Supreme Court is made up of 9 justices that decide the rules that we live by. They aren't the ones that necessarily come up with the rules or draft the bills or laws, but they're the ones with the ultimate decision on deciding whether a law is just or not in a court case. This matters to you because if there's ever a question about whether you've been wronged by the Constitution, they're the ones to take it up, and they're the ones with the final say on whether or not, on which direction the Constitution will go. They're people just like you and I. They all have their own opinions. We have all the justices on the bench today are Stephen Breyer, Clarence Thomas, John Roberts, Ruth Ginsburg, Samuel Alito, Neil Gorsuch, Sonia Sotomayor, Alana Kagan, and Brett Kavanaugh. The most recent 3 were Neil Gorsuch, which was put on the bench by Donald Trump, Brett Kavanaugh, which was the most recent, also put on the bench by Donald Trump, and Alana Kagan, which was put on by President Barack Obama. The Supreme Court represents one branch of the government, the judicial branch. There are 3 branches: the executive, legislative, and judicial. The judicial branch, which is what the Supreme Court is part of, is made up of the federal courts, state courts, and Supreme Court. All 3 of these branches stay in check by the checks and balance system. The legislative branch has the House of Representatives, and the checks and balances are shown in this. The executive is the president, and checks and balances just make sure that no one branch of the government is gaining too much power. So vetoing bills, impeaching, bringing up laws, all those things are responsibilities of different branches of the government. The United States stays fair with this system because they want to make sure that there's no corruption. They do this also with the jury system. So it's not just one person's decision, it's a collective group decision. The Supreme Court is basically a group of justices deciding. Some other countries that also have judicial systems similar is Japan and Germany. Germany has a court system very similar with the federal court at top. It's not called Supreme Court. Japan does have the Supreme Court, and they both do have juries as well. But South Africa, Thailand, and India, all 3 do not have jury systems. This kind of prevents them from staying as far away from corruption as possible. There's a little bit of a correlation between like first and second world countries and juries, and third without juries. With Abolition of Juries Act is what a lot of the have ended the jury system in a lot of the countries. And yeah, a little bit more about the history is going to be for Nate.
So the Supreme Court was originally established in 1787 by Article 3 of the Constitution. It was much different than we know the Supreme Court today. For example, there were only 6 justices, so there was no clear majority if there was a split. There was no government building for the Supreme Court to operate. For example, they used different facilities, government buildings in Philadelphia to use whenever they were open. So there obviously was never a designated spot for them to review cases. Another thing is there were only 86 cases reviewed between 1790 and 1801. This is very different from these years because in 2018, there were 70 cases reviewed by the Supreme Court. That means in 11 years, in the 1800s, there was only 16 more cases than 1 year, 2 years ago. The Supreme Court was also notably weaker than it is now. In a case, Griswold versus Georgia, an individual citizen sued against the state of Georgia for belief that he was wronged by the government. The Supreme Court reviewed the case and agreed with the individual, saying that the that Georgia had overstepped their boundaries, but Georgia decided not to listen to the Supreme Court and overruled their decision, and the individual did not receive any retribution for a case that he won in the Supreme Court. So the Supreme Court started to strive towards becoming a co-equal branch in 1801 with John Marshall. John Marshall was a soldier after the Revolutionary War, and he also was a politician before he became a Supreme Court justice. He was elected by John Adams to the Supreme Court and quickly became the Chief Justice. There were a lot of notable things that he did. For example, he struck down the first ever federal law in Marbury versus Madison. Marbury Marshall was a judge nominated to become a federal judge by John Adams, but then Thomas Jefferson, after being elected, denied his ability to become a Supreme Court judge. The Supreme Court then saw the case and decided that Marshall should be allowed to be a federal judge, and struck down the law that Thomas Jefferson used to prevent him from becoming a federal judge. Other notable historical cases during this time period was the case of conspiracy against Aaron Burr. Aaron Burr was the man who killed Alexander Hamilton in a duel, and he was fought for conspiracy with the British government after he fled. This was another case that John Marshall was the Chief Justice for. Overall, John Marshall increased the jurisdiction of the Supreme Court. He defined the Constitution as supreme written law. He also believed that the Constitution and the government should serve the people. For example, a quote from him is, "The Constitution is colorblind. And neither knows nor tolerates classes among citizens, allowing everyone to be equal." He notably fought against Jefferson and Jackson. Andrew Jackson liquidated the National Bank when he was president, and he fought to limit the power of the Supreme Court so that it could not keep his power in check, but the Supreme Court was allowed to keep the power and fought against him to limit his overbearing presidency. They also went through a brief Reconstruction period. After the Civil War, there were 9 Supreme Court justices established, and they often adjudicated the 13th, 14th, and 15th Amendment, which ended slavery, gave African Americans citizen in the U.S., and also gave them the right to vote.
So the nomination process. The nomination process begins when there is a vacant spot available in the Supreme Court. So vacant spots can be due to retirement, death, or impeachment. Impeachment never happened, but it is a possibility. So an example of this is Neil Gorsuch, when the Justice Antonin Scalia died. So there was a vacant spot, and Trump nominated Neil Gorsuch. So after Neil was nominated, he got sent to the Judiciary Committee, and the Judiciary Committee is made up of 22 U.S. senators, and they ask questions and they ask for your personal views. So this process, the Judiciary Committee process, is called a hearing, and during this hearing they go through your background. So another example of this would be the Bret Hart being nominated. When he was nominated, there were allegations towards him from Christine Ford, and So the Judiciary Committee process takes around 60 days normally, and there was a case where the longest it ever took to confirm a justice was 125 days. This case was President Woodrow Wilson, and he nominated Louis Brandeis in 1916. And this process took 125 days to, so Louis Brandeis could be confirmed. So, so once approved, the nominee goes to the full Senate. Then the full Senate votes. And majority of the votes win. And if there is a tie, the tiebreaker is the vice president. So once confirmed, the nominee takes 2 oaths. The first oath is the constitutional oath, which is the next slide. And this oath says, I, then the name of the nominee, do solemnly swear or affirm that I will support and defend the Constitution of the United States against all enemies, foreign and domestic, that I will bear true faith and allegiance to the same, that I take the obligation freely, without any mental reservation or purpose of alienation, and that I will well and faithfully discharge the duties of the office on which I am about to enter. So help me God. So what this is basically stating, or what it means, is that the judge has to do well by the Constitution, not by its personal views, or not by their views. They have to do right by the Constitution. And then the next oath is the judicial oath. I, and the name of the nominee, do solemnly swear or affirm that I will administer justice without respect to persons, and do equal right to the poor and the rich, and that I will faithfully and impartially discharge and perform all duties incumbent upon me as blank, under the Constitution and laws of the United States, so help me God. So this oath basically means that the justice will not take sides and will be fair towards the cases that they review. So once the nominee is approved, they are justice for life, or until they retire, or if by any case they get impeached.
So the Supreme Court is really important, and it's the most important role in our constitutional system government, because it helps us, it makes sure it protects our civil liberties and civil rights, and makes sure that our constitutional rights are secured within the cases. The Supreme Court is the highest court in the U.S. and is usually the last resort for justices for other people, because they usually go to lower courts before they go to the Supreme Court, because that means the amount of times that they went to the lower court and did not get the result they wanted, so they have to go to the Supreme Court. With that, the Supreme Court annual term starts usually on the first Monday of October, and usually lasts until June or July of the next year. And in that term, they have a lot of responsibilities, but their usual day-to-day responsibilities are, so when they first start the term, they start reviewing cases. And reviewing cases is really hard because only a small percent chance actually get to be heard in the court. Sorry. Reviewing the case, they go on the rule of 4. So the rule of 4 is when 4 out of the 9 justices vote saying that they want this case to be heard in court because it needs to be heard. And they do this, it's not really by law, there's not a law about the rule of 4, it just works best for them, and they've been doing it for years now. And after they review the case and pick a case to be heard, they get heard in the Supreme Court. And when they're being heard in the Supreme Court, each side only gets 30 minutes to present, and they only get 30 minutes because there's no trial. So there's no other people listening, it's just the 9 justices. So during the court hearing, they hear each side, and then after they then go into a recess, and this is called judicial review. And judicial review is like the most important part in the judge's like day-to-day thing, because it can take about 2 weeks, it could be 2 week long, and the judges during that time discuss the case and what they think about it. And while they discuss that, they can write opinions, and usually the opinions do not affect the results of the case, it's just what they think. And when they're done reviewing it, they then take a majority vote, and the majority vote then wins. For example, in Madison versus Alabama, Madison was trying to fight the death penalty because he claimed that he couldn't remember committing the crime, and that's under the 8th Amendment. But what he didn't understand was the 8th Amendment protects people who have mental illness. He was on death row for 30 years, and on death row he went through several strokes, and those strokes caused him not to remember the crimes. So to that, they voted 5-3, stating that he still gets to be executed because he was not mentally incapable at the time. It was due to the sitting of like him actually being in jail and him going through the strokes is why he forgot the crime he committed. So the 8th Amendment did not protect him in that right. So the majority vote won that one, even though 3 people voted that he shouldn't have been executed, but most people voted that he should. So once the majority vote is taken, the most oldest judge or supreme judge in the justice then writes a case opinion with all of the results in it. And then lastly, they go back into court and then they say the results. And while in it, they're not allowed to discuss. During the 2 week period, the judicial review, they're not allowed to discuss it with anybody else. And yeah.
The Supreme Court handled many impactful cases that affected American law, such one being Shelley versus Kramer, Miranda versus Arizona, and Buck versus Bell. For Shelley versus Kramer, it involved racially restrictive housing codes that prevented African American families and Asian American families from living in certain American cities. This certain case was brought by Lewis Kramer after the Shelley family and African American moved into the neighborhood. He tried to get the Supreme Court to enforce these racial covenants so but the Supreme Court unanimously voted that those with restrictive covenants violated the 14th Amendment's Equal Protection Clause. And because of the ruling in this case, it led to him doing many legal housing segregations being enforced. Another important case was Miranda versus Arizona, which was a case that helped introduce Miranda rights. For this case, Ernesto Miranda was arrested on circumstantial evidence and while being arrested and interrogated by police, he was told he waited a confession saying that he did. But it was revealed later in the case that his attorney was not present during when he waited, so the court ruled that his confession was inadmissible in court. And this led to what we know now as Miranda, which is you have the right to remain silent, anything you can say will be used against you in a court of law. You have the right to an attorney if you can't afford one will be right for you. Do you understand these rights with these rights in mind? Do you wish to speak to me? Another case was Buck versus Bell, which involved a feeble-minded woman who was confined to a mental institution after being raped and pregnant by her foster cousin. They did not take long and they had to sterilize her because of her feeble-mindedness and that she did not have a right to have any children because of it. The court didn't really take long to decide that they went against her 8-1 because they feel as though sterilizing her would actually just help America get rid of feeble-minded individuals. Right? One of the justices actually said 3 generations of imbeciles is enough after this case happened. Some other impactful cases that happened were Brown versus Board of Education, like I mentioned, Marbury versus Madison, Dred Scott versus Sanford, Matt versus Ohio, U.S. versus Nixon, Obergefell versus Hodges, Levin versus Virginia, New York versus Sullivan, Terry versus Ohio, Roy versus Reagan, and Gideon versus Amanda.
Okay, so to summarize, we went over the history of the Supreme Court. At first, it was a weak court that didn't have very much jurisdiction, and states could pretty much not obey the court's ruling. But thanks to Chief Justice John Marshall, these things were changed. The number of justices, which were originally 6, became 9 justices. And more power was given to the Supreme Court as an actual third branch of government. This also led to being able to interpret the 13th, 14th, and 15th Amendments concerning slavery and race issues. We then went over the nomination process to become a Supreme Court judge. Of course, there must be a space available. Judges are removed either by having died, having been impeached, which has not happened in history. And in order to become a Supreme Court judge, you must be nominated by the President of the United States. You then go through a process of going to a hearing held by a Senate committee, being asked questions to determine your validity as a justice, and after these proceedings, the Senate will vote on whether or not to appoint you as a justice according to a majority vote. And once justices are appointed, they are appointed for life. Responsibilities of a Supreme Court judge include a process of debate through all of the cases that they hear, of which of all the cases submitted, they only hear a small percentage of them. As you can see, the Supreme Court has become more efficient than it was in the past, and it is able to hear more cases. They go through a debate process, and rulings are determined by a majority vote. Impactful cases overseen by the Supreme Court include Shelley versus Kramer, a case concerning housing segregation that was determined to make segregated housing illegal. Miranda versus Arizona, in which a man was not known his rights, did not have an attorney present, which led to the creation of Miranda rights, and Buck versus Bell, a controversial case that involved the sterilization of feeble-minded people. And these are the things that we went over. But why should you care about these things? Well, the Supreme Court interprets the law as a third branch of government. We are the people of the United States of America, and without the judicial system, we couldn't fight for our rights and get what we think is necessary and have the law go for what is right. So the Supreme Court is basically the top of this system and is necessary to keep things in balance for the whole government. The decisions of the justices are final, and their decisions are what help keep the laws and the Constitution in place. You may know that the political landscape of America is quite divided, left versus right, liberal versus conservative, Democrat versus Republican. But even no matter what opinion you have, you can depend on branches of government to still use laws that have been laid in place for hundreds of years to help you have your rights, even in times when all of our opinions are divided and rights may not be upheld, we still have the Supreme Court to uphold law for us as the people. Thank you very much.